and this podcast is for informational and educational purposes only and does not constitute financial advice. Please consult with a qualified financial professional for advice specific to your situation. The views and opinions expressed are those of the hosts and guests and do not necessarily reflect those of the podcast producers or sponsors. We make no representations or warranties regarding the accuracy or completeness of the content. Hi, my name is Bella Carrasco, and helping others feel more comfortable about investing brings a huge smile to my face. After working in the private equity, family office, and securities markets for nearly a decade, I pulled together my resources to interview experts in each area of the due diligence process and answer how do you know questions when considering your future financial safety. We go deep into questions about many phases of the investment process, with the goal of helping you go from practice to game time confidently. This is the How Do You Know podcast. We're learning about the legal documents associated with private investments from Robert Cherry, who is a business and IP attorney handling founder issues, mergers, federal and state securities law, capital raising, copyright, and outside general counsel services. So Robert, so grateful that you're here because private placement memorandums and operating agreements can be scary and ominous. So would you mind just starting with what a PPM and operating agreement are and maybe the structure and typical terms of each?
Yeah, sure. Thanks, Bella. Yeah, happy to be here. A PPM or private placement memorandum is primarily a disclosure document, whereas an operating agreement is your sort of main governance document in terms of how a company is run. So PPMs, you're often seeing these in the context of some type or some form of capital raise. PPMs, the sort of the more voluminous of the sort of disclosure document options. You're going to see sort of a quasi-business, quasi-legal document. So you're going to see information about the company. You're going to see like sort of boilerplate securities law disclosures. You're going to see an offering overview, sort of talking about the terms of the offering. You might see some company profiles, officer bios, director bios. You'll see a use of proceeds. You'll see investor qualifications. You're going to see a big section on tax. You may see some key terms from the operating agreement, some stuff to sort of highlight everything that's going on in this offering. The biggest sort of most important piece of this document is going to be the risk factors. So there should be a dedicated section discussing risks associated with the company, the industry they operate in, the offering itself, what it's, owning an interest. And usually what you're looking for here is all the reasons why you should not invest in this particular opportunity. And so it's always good to sort of evaluate these risks, review these risks, read them carefully so that you get some sort of understanding as to what's going on. If they're properly drafted, they should be tailored to the deal and to the company. So you should get some pretty good insight into what's actually going on. I say that because this process of raising capital or becoming familiar with a company or their founder or whatever it is, sometimes they're selling. So you're getting a lot of marketing stuff, you're getting a lot of sales pitches, you're getting all this stuff. And so you may not have a clear idea of what is going on in this particular company, where if you get into the risk factors, assuming they're put together properly, they're going to sort of give you that no fluff, no sales, no marketing language, like straight to the point, risks that are associated with this opportunity. So, for example, the founder has never done this before. We have no money. We have limited operating history or whatever it is, to sort of get some sense of what's actually happening. So it's a good opportunity for that. And so then the other sort of main deliverable in like the capital raising context is going to be the operating agreement. And when you talk about operating agreements, there may be some sort of analogous documents in corporate context, like corporations. Maybe it's a stockholders agreements, or there's some sort of voting agreement or something that is somewhat analogous. And then in the context of a limited partnership, which you'll sometimes see in the sort of fund world. This sort of GP LP structures will have a limited partnership agreement. So they're going to vary slightly, but broadly they're very similar documents. And so you're going to see decision making, what you're allowed to vote on, what you're not allowed to vote on, how that stuff works. You're going to see the economics, how distributions are made, how allocations are handled, whether there's like mandatory capital calls or what's your sort of capital commitment. You'll see a bunch of tax and accounting stuff. You're going to have all your restrictions on transfer. So you might see a right of first refusal. You might see drags and tags. You're going to, be looking for information rights. What right do I have to financials, quarterly financials, annual financials, tax deliverables at the end of the year? More broadly, do I have any right to sort of the books and records of the company? You'll see who's running the show, who's the manager, who's the GP, how do we replace them? What's their sort of standard of conduct? Are we waiving fiduciary duties? Do they have some sort of minimum time commitment? You'll see sort of miscellaneous stuff like confidentiality, maybe restrictions on other business opportunities or self-dealing, maybe transactions between the manager and the company or certain interested persons and the company and how that's handled. And then disputes. So how are disputes handled? Are we doing, is there mandatory mediation? Is it arbitration? Is it litigation? Where's the forum? So that's sort of the high level overview of PPM and the operating agreement and kind of their significance in what you might find within those documents.
Thank you for laying that out. Obviously not a fun Friday night read, but still important to understand. And I know you alluded to there's the top risks that are in these documents, and investing doesn't come without risk. So it's just understanding what the risk is and if you feel comfortable that the mitigants are worthy of the investment. So, what are terms that investors should run away from when they see something in the PPM?
Every deal is different, and kind of like you said, you're trying to size up the risk so that you can appreciate the risk and then make a sort of informed decision about what you're doing. For me, sort of initially and practically, I'm trying to size up the quality of the documents, sort of. So like it's kind of an easy tell if the documents themselves are like seemingly poorly put together, or they're unsigned or in sort of disarray, or there are conflicting terms between the PPM and the operating agreement or the subscription agreement. Are they referencing documents that I don't have? Just kind of trying to figure out, do these docs pass the legitimacy test? Do they seem like they're on the up and up? There's a lot of people out there raising capital with varying degrees of sophistication, and sometimes you may not really know. You just assume that they present well and they have their stuff together, but then when it comes down to the paper, you're like, this is kind of not adding up. So that's kind of like the first thing I try to do is see if these docs pass the sniff. And I'm looking for terms that stand out, that are particularly not the norm, right? So I'm looking for random repurchase rights. So they have the ability to come in and take my ownership for some reason. Are there mandatory capital contributions beyond what I'm committing to do? What are my information rights? Am I getting annual financials or quarterly financials? Are there broad waivers of fiduciary duties for the manager or for officers? How are docs amended? Can they unilaterally or seemingly unilaterally amend these documents to sort of change the deal? And that's kind of like an initial pass. That's what I'm doing. I'm trying to sniff out whether or not these things were put together well, whether they make sense, whether I have all the documents and information I need that are referenced within the document. I can look and see. Usually, there's like a legal counsel provision. I mean, maybe this is just a lawyer thing, but I'll look and see, okay, who prepared these documents? What do they make sense for the context? Are they a relatively sophisticated law firm, or do they do EWIs and capital raising, like something that doesn't make sense? But and then I'm looking for these sort of major concepts that stand out or seem like they sort of run against the norm.
And I know you mentioned contributing capital. So how often do you see that? And is it a deal breaker when you're looking at the document?
The ones where we're committing to a certain amount to pay whenever you call it due, the sort of cap on that commitment amount is always pre-agreed. I don't really ever see an obligation or an ongoing obligation to contribute capital beyond what you've committed to contribute. And then in that context, you're also going to have is another thing to look at, or at least to appreciate what happens if you don't contribute that capital.
Yeah, diving in deeper if you see those.
For sure, yeah.
And then circumstances for investor votes. Is there anything to be wary of there?
Again, it all kind of comes down to the deal and the context. We have deals where members have little to no voting rights whatsoever, right? Maybe there's just some threshold requirement to get some type of approval for amending the agreement. We like to see this sort of like big handful of major decisions. So you'll see like dissolution, maybe manager replacement, entering into a merger, selling all the assets, again, amending the agreement. These are sort of the main biggest decisions that we would be reasonable to see, because again, a lot of the day-to-day or operational authority, or really just all the authority for running the company itself, is going to be left to presumably the manager, and these members are not really involved in the day-to-day. And then in the fund context, I wouldn't necessarily be surprised to see sort of passive investor type role.
Right. And digging in deeper into removing the manager, is there a percentage that's fair for investors?
This is going to vary, and we have deals where you can't remove the manager because, again, it's getting back to this idea that you're investing in the person, right? So it's not so easy to just replace that person. So say it's a restaurant deal or something. You're backing that person, and that person is your friend or your family member of some type. And so it's really this person, or who we don't, who's actually going to step into this role and do these things. In fund world and in these larger funds, it's obvious, it can be easier to replace these people with larger institutions. They have other people. There are other institutions to sort of step into these roles. The way that voting sort of shakes out, generally, you're going to see, call it majority approval, supermajority approval, and unanimous approval for simplicity. And then you have a causal standard, right? So how can the manager be removed? Usually some high level of cause, and that's usually defined in the operating agreement. So it would be not typical or exceedingly low threshold for a manager to be able to be removed with a majority vote. On the other side of that spectrum would be a supermajority vote or a unanimous vote, and then you probably wouldn't see a causal standard. So somewhere in between there is usually where this thing shakes out. So majority vote with a causal standard, supermajority vote with or without a causal standard. That's kind of the world you're probably living in.
So it sounds like, because I'm a passive investor, when it comes to investor voting or removing a manager, if there are no real decision rights, it's not a huge red flag because you're kind of signing up for a more passive investment.
Yeah, appreciate what's going on, and if that makes sense, I don't think it's necessarily crazy, And then you also have another thing to look out for, like I mentioned, is this idea of a waiver of fiduciary duties, because contractually these people are obligated to do what's in the operating agreement, and then they also have an obligation to you as a member, and that's what these fiduciary duties are. And yeah, so you can sue them, so it's not, you're not without recourse. Not that suing is a great option, or an efficient or inexpensive option, but it's an option that exists nonetheless, right? So if you're in this thing and you're getting some reporting, and something doesn't seem right, and you're being mistreated in a way that they're misappropriating funds, or they're making wildly poor decisions, there is some standard contractually, presumably in the operating agreement, and just under the law more generally, that these folks are going to have to live up to. So,
I think that questions I get from investors are out of fear that since this isn't SEC regulated, how am I protected? So glad that you brought that up because that you do have some rights still.
and so there are some securities law regulations that relate to these private offerings that also create potential liability for folks.
Right. And then moving along to fees, what's typical and what's not there? Is it typical for a management fee to be paid before the waterfall?
Pretty much always see the management fee come out separately. I think that we're still in a world of 2 and 20, and everything is sort of getting tied to that metric. So you might see the 2% go down over time, or it might start off higher, but the math is somehow always tying back to this idea of 2 and 20. And that 20% may scale up, but you're going to see some pretty significant performance hurdles for that to happen. That 2% fee is absolutely separate from the waterfall, and then the waterfall may shake out any number of different ways.
And can you just to discuss the difference between an American and a European waterfall structure?
Basically, when you're talking about waterfalls, you're talking about how distributions are made, and that's what that 20% is. And so I believe the European sort of structure is investors get their capital back first plus a pref, and then the manager will participate at that 20% after that. The American version, they don't get their capital back first, and there may be a pref that they get first, and then the 20% kicks in. So the difference really being, America, maybe you get the pref, you definitely don't get the capital back first. European, you get your capital back plus a pref first.
And there really isn't a right or wrong there, right? Those are kind of just two standard waterfalls, or do you have a preference over one?
I think that maybe in your world, if I'm not mistaken, it may be more common to see the sort of European waterfall in real estate deals. And so it's really kind of just depends on what's happening in the market, what type of deal it is. Obviously, you get paid back more money first in the European.
Yes.
So that's going to be important. And then I think another thing, like unrelated, that I think is important to mention is that management fee, that 2%. You're going to be looking in the operating agreement or the limited partnership agreement to try to understand what expenses the manager or GP can charge to the funds, and what expenses should fall under that 2%. And so there's a decent amount, or potential for a decent amount, of gray area in terms of what goes under what, right? You would expect their salaries to most certainly be a part of the 2%, whereas, travel expenses or something to go visit with these investors is kind of a big category of stuff that they might be able to expense to the fund. And so looking at those expenses and looking at the management fee and what falls under each is an important exercise. And then perhaps even simpler than that is capping the expenses. So if there's a cap on the expenses, you really don't have to, well, I mean, it's still important to understand what they're able to expense, but you have this cap that exists so that they can't exceed it. So your expectation is that's how much they're going to spend in addition to the management fee.
Right. And does the PPM typically disclose what fees are in this expense, or how can you tell if something's standing out between the management fee or this kind of expense load?
In a PPM, again, this is a full blown disclosure document. So it's pretty long, it's pretty voluminous. They're trying to get everything that's material sort of in that document. So they're sort of flagging stuff for you. So we'll most certainly see a section or a piece of it that's talking about the management fee. I would expect to see if there's a cap on expenses, I would expect to see that. If I were preparing the document, there would be a discussion of the fee, the expenses themselves, and what's expected to fall under the management fee. But all of that will come out of the operating agreement or the LP agreement. So you're seeing it in the PPM. It may or may not have a reference to where it shows up in the operating agreement, but it certainly shows up in the operating agreement. And ultimately, that's going to be the document that sort of controls, right? They're going to say that the PPM is qualified by the actual document that it relates to, which would be the operating agreement or the LP agreement.
And I know you mentioned the cap. So if there is no cap, how do you get comfortable with that gray area?
It all goes back to appreciating risk. Who am I investing in? Sizing up the company. What's my relationship like with the manager? What's the level of trust? What's my appetite for losing all of my money? Those sort of things. That LP association that I mentioned, they have a lot of resources and materials that form documents, and they sort of all influence the way that these things are put together. So I'd be curious to see what they say about caps on fees and what's going on there, because that would be potentially a sort of signal as to what's different about this deal as it compares to others. Is it similar to this sort of standardized world, or is it something different?
And I think you can even ask, like, what's a typical expense load? Because I feel like it's usually around 2 to 3%, which is really negligible.
Yeah.
But I do always like to say you have to risk it to get the biscuit.
There you go.
So
yeah.
These items shouldn't deter you from making an investment. It's just a matter of, like you said, trusting the sponsor, doing your due diligence, which is why I have like a whole episode dedicated to that topic. But along those same lines, what are some troubles you've seen syndicators or fund managers get into legally?
It's a failure to disclose material information. So if you under securities law, you have an obligation to make these disclosures. And so if there is something kind of a simple way I think to put it is if there were some piece of information that would have changed this investor's mind about making this investment, you should tell them, and that should have been told to them. So it's a potential pitfall in terms of legal liability. And then relationship management, poor investor communication, not doing what you say you're going to do, not responding, not managing these relationships. And that's, I've seen litigation where the investor was just mad. But this situation that I'm thinking about, I mean, the guy was very wealthy. It was a relatively nominal investment. He just wasn't getting any information, no updates, no meetings, no responses, and he was just pissed. poor investor communication and management. Maybe some other sort of regulatory matters, securities law stuff.
Right. Yeah, I guess a question for the sponsor would be, how often am I communicated with? Do you issue quarterly reports? Do I have access to the financial statements? But is there any other way to get in front of any of this by asking a specific set of questions?
So all of it's going to be in the document. And so
Okay.
in the operating agreement, presumably in the PPM, I mean, you should read the documents because it tells you a lot. You'll be the only person that reads it. And it's kind of worth it because you learn a lot and you can understand it. And if you don't understand it, then there's a problem with the drafting. A lot of people get overwhelmed by legal language and this and that. And it's just reading comprehension. If you can't simplify it, if you can't break it down in a way that it makes sense, it's probably not good work. And so that could be a signal to you. But getting back to what we were talking about, even if you don't read it, if you're doing some sort of quick and dirty review, there's really only so many things that you're looking for. And so you could control F for books and records. You can control F for information. You could control F for financials, right? All of this stuff to try to see what information rights you might have. Again, like the sort of big bucket of stuff that you're trying to understand in an operating agreement is really the economics, the distributions, how are they made, and that shows up in one place, basically. It'll show up in the context of dissolution, but there's one main place that it shows up, and it may just be one section for distributions in the economics. Capital contributions, another important thing. Where's the section that talks about that? Is there anything funky going on there? Do I have some obligation to contribute more capital than I'm committed to contribute? And then what you're looking for decision making. How are decisions made? You're looking at finding the voting standards. Is it majority? Is it supermajority? Is it both? How are they talking about it? Look at the table of contents. Where's the section on voting? Try to figure out, quickly size up what's going on. Documents have the habit, particularly in voting, that it's just all over the document, unfortunately. So you may find some investor vote here, and then 28 pages later there's another one, and everywhere in between, stuff that's pretty well put together. They're gonna consolidate most, if not all, sort of member investor decisions to one section. So yeah, info, economics, voting, and then you're looking for waivers. And what degree are they trying to make these waivers, or what duties do they exist? Do they have some sort of duty of good faith and fair dealing, or is it some broad waiver, something that sticks out and seems really dramatic? And those are things that you can find yourself if you wanted to and you were inclined to do it. But we're usually on the issuer side, and so I'm the one preparing the company or the fund's documents. And so what I'm doing is reviewing the documents and preparing doing all the things that I talked about as efficiently as possible, just so that they have some sense. I'm saying, here's what's going on, this and the this and this, and these things are weird, or these things are not good, or not typical, but this is sort of a bullet point idea of what you're signing up for. And sometimes it doesn't seem right.
And to your earlier point about comprehension, I do think that a lot of these documents are relatively the same. So once you get those repetitions in, it's easier to spot these things and you can go through it much faster.
100%.
But let's just say I hate reading. I don't want to spend any time on these 100+ page documents. Can someone come to you and say, hey, can you just look at this and tell me if anything looks off? Like, do attorneys offer that service?
For sure. Attorneys offer every service. I guess I hesitate because there is this world where people are like, hey, can you look over this for, $500 or whatever? It shouldn't take you long. Like, look at it for $50 or whatever, whatever the number is. And you don't know that person. And so we're
Yeah.
talking about, identifying risk and all of this. I mean, for me, as an attorney, like, I can't go through those documents in an hour or 30 minutes. There's stuff buried. So I need to at least be flipping the pages and skimming the vast majority of what's going on, right? Otherwise, I get into this situation where this guy gets upset because something happens or he doesn't understand something. And it's only because there's not a relationship there.
Right.
And so we just need to know what level of service you're getting and what you're paying for. Like, what's the expectation about what you want? Like, let's just have a conversation and be clear about that.
That's a very fair point. So maybe just get familiar with the legal documents, and if there's one or two things that you want reviewed, maybe that's when you can reach out to someone. Or I don't know, if you really do need help, then maybe it's kind of like do a side by side with them so that you can continue to learn until you get more comfortable.
Yeah, totally.
Well, the last question I have for you is about the legal structures. So typically you see LLCs, but if it's a TIC or any other structure, is there any warning signs there that people should be aware of?
Not really. I see a lot of GPs and LPs, and I see a lot of like manager managed LLCs. They all sort of generally mirror the same fundamental principle, which is there's this separation of authority between the manager or the main person and then everyone else. And so in a GP LP structure, you have the general partner who serves in this sort of manager role, has certain authority that is greater than and different from the LPs, which are the investors. And then they have their own sort of set of rights. By comparison, a manager managed LLC pretty much mirrors that same structure. You have the manager of the LLC who sort of serves on that GP role, and then you have the members of that LLC who are analogous to the LPs. And so one structure over the other would necessarily tip me off to anything. If you're seeing something that doesn't sort of make sense, it might tip you off that something's weird or unnecessarily complicated, or there's some type of something funny happening. So it all comes back to the main contract deliverables. That's the contract that you're really subjecting yourself to. So fundamentally, it's understanding what's going on in there.
Good.
At the end of the day, it all comes down to the contract that you subject yourself to. But from a securities law perspective, they do have an obligation today to provide you with whatever information, all material information, or, more practically just whatever you really want. So ask questions, get the documents. Like, that's going back to my first point, which is if you're seeing stuff that's referenced in here that's, you don't have, get it, get a cap table, get a membership, registry, or get the certificate of formation, get all of these things. They have an obligation to do that. And also it's probably a good exercise for seeing how they handle you. They do have an obligation to do it. And so are they, forthcoming with this information? You start interacting with them more, it's more opportunities to learn. And so that's an easy one too. Even if you're not inclined to read the documents or whatever, it's just like, let's just see if they are, helpful. If they're willing to provide this information that I know they should be. And so just opportunity to learn about what this relationship might look like down the road.
Yep. Again, and to your point about really making sure you're comfortable with the sponsor, in conversation after conversation, a theme that comes up is don't be scared to ask questions, because it can actually be very revealing about who you're about to get in bed with, so to speak.
Yeah, totally.
Well, good. Let's end with a quick fire round of questions. And the first one is, what is your favorite restaurant?
In Austin?
Anywhere, whatever comes to mind first.
I think my favorite restaurant in Austin is probably Monger's or Commodore.
Oh, I've never heard of that.
Yeah, Monger's.
Commodore is good.
Yeah, Monger's has like a special place in my life, so it's just always been
Got it.
Yeah.
Cool. Nice. Second question is, what brought you joy this week?
My wife got a new car, and
Oh, nice.
I was working in the living room, and I could see her driving up and down the driveway, back and forth through the window. She would just pass by me.
That's awesome.
Yeah. So
What kind of car did she
she
get?
got an X3.
Okay.
Yeah.
That's adorable. I love
Yeah,
that.
it's awesome.
Final question is, what is your favorite way to stay up to date on the news?
I guess I'd say I'm an avid Googler,
Okay.
and like an independent researcher. So I'm constantly looking for information and sort of observing and seeing what's going on in the world, whether it's through interactions with colleagues or clients or whatever, and then I'm going back to Google, and kind of doing some independent research. I have I also, it's not really news, but I joke with a friend from high school actually about our panel of experts, and so I'm constantly consulting people in my network with specialized knowledge, whether it's you know highly sophisticated or what kind of peanut butter I should buy, So
Yeah. It's important stuff.
Yeah.
And growing up, every time I would ask my dad a question, he'd be like, go look it up in the dictionary or whatever it was back then.
We had those encyclopedias, we carried around for years.
Yes. But it's a good skill to have. You have the world at your fingertips. Just Google it.
Yeah, and there's a tremendous amount of information. You have to know how to get through all of it efficiently, and know that like how you present it is what it spits out. So you're gonna have to look at all the different sides, and
right.
Oh, that's a fun exercise.
Well, Robert, thank you so much. Why and how should people reach out to you?
If you need legal services, people could reach out. So, like you mentioned in the beginning, I'm a business attorney, and I do some sort of specialized IP litigation. So we do, business formation, drafting these sort of governance documents that we're talking about. We do capital raising. We do buying and selling of businesses or mergers and acquisitions. Then we kind of do what I call outside general counsel type stuff. So anything contractual in nature. And then I also just happen to do some copyright litigation as well. They can contact me. My website is rcesq.com. I work with a firm in Austin called Syndicators Law. Their website, syndicateslaw.com. And then I also work with another law firm with the IP litigation stuff out of California, and their law firm is donigerlawfirm.com. So yeah, any of those places, you can reach me. I'm also on this site called clarity.fm. And I believe that the link is clarity.fm/Robert Cherry. And it allows you to schedule paid phone calls, and sort of facilitates all the back end of scheduling and stuff.
Perfect. Well, I hope people now feel more equipped to tackle those lengthy PPMs and operating agreements. Yeah. Until next time.
If you're not asleep.
Adios.
We'll see you later. Bye.
If you are ever interested in a recap with the main points discussed throughout the podcast episode, check out the Q&A series, because we dig deeper into the concepts discussed, and you can follow along on YouTube if that's preferred. If you find any value in the show and want to support it, it would be awesome if you texted someone right now about it. You can say you have a podcast recommendation that you think they should listen to, and then ask them to get back to you with their thoughts. Anything helps, and I really rely on the amazing investors like you to spread the word. Thank you so much for listening, and please feel free to reach out at any time.